Good afternoon, everyone, and thank you so much for joining Bradford and Barthel's webinar on affirmative defenses. Don Barthel and Amir Adil are leading today's 90-minute presentation. We'll do some introductions. Let's start with Dan.
Good afternoon, everybody. My name is Dan Stevens, and I'm an associate in our Ventura office. We cover the Oxnard, Santa Barbara, and San Luis Obispo boards, so we have lots of agricultural worker cases. And I have to say, as a proud Baltimore Ravens fan, I'm still struggling with what happened last night.
Thank you, Dan. Emma.
On that note, I apologize, Dan. I'm a Raiders fan, so anyway. Good afternoon, everybody. Thank you so much for having me. My name is Eva Carrasco. I'm a partner at the LA office. We cover the Marina del Rey and Los Angeles venues. We basically administer cases across the board and specifically trucking cases as well. I am a Raiders fan, it's a fun fact. And I bike 26 miles every week. Might not look like it, but I'm very tan as well. So thank you.
Thank you, Emma. That was a great game last night. Rob.
Good afternoon, everybody. I'm Rob Tallman. I'm in the Anaheim office. We handle cases in Anaheim, Santa Ana, and the very dysfunctional Long Beach board. So if you need any help with any cases in Long Beach, let me know. It's not easy, but we do have success there. So, and Dan, I'm sorry about last night. That was pretty crazy. A fun fact about me, and this is almost an admission more than anything else, I did used to work for the dark side, so I do have applicant attorney experience. Goes back a while, but actually I do think that experience gives me some advantages. I know how the other side looks at these cases, so if I can help anyone out, I would be happy to do so. Thanks.
Thank you, Rob. And next we have Tamina Ahmed. She is our Chief Marketing Officer, and she's going to introduce today's speakers.
Thank you, Tammy. Good afternoon, everyone. Thank you so much for allowing us into your homes, into your offices. We know not everyone is back, and we look forward to seeing you guys back in the office soon, someday soon. I am the managing partner for client relations at Bradford and Barthel, and I've had the pleasure of having this role for the past 12 years. I've been with the firm for 23, and we are going to be celebrating our 25th anniversary next year. You have my contact information in front of you. Everyone, all the attorneys here have their contact information, so feel free to reach out to us. Thank you again for giving us your time, and now it's my pleasure to introduce two of my favorite speakers, Don Barthel, our esteemed founding partner, and Amir Adil, our managing partner and our equity partner out in our San Jose office. With that, I'm going to let Don take it away.
Good afternoon, everybody. Thank you so much for being brave enough to join us. Amir's going to do the batting cleanup. He's going to take the second half. I'm going to try not to make you fall asleep during the first half. I apologize. The law is not exactly my strength, but neither are jokes. And here we're going to try anyway because I've got to maintain my reputation for bad jokes. So the two elderly couples are hanging out at one of the couple's homes, and the two fellows are in one room and the two ladies are in the other room. The first gentleman says to his buddy, "Hey, wife and I last week we went to a new restaurant. Excellent food, service was good, and the price very reasonable, very reasonable." Well, his buddy says, "Well, you know what? We're always looking for a new restaurant. What's the name of this one?" First guy goes, "Oh shoot. Oh, okay. What's the name of that flower? That red flower with a long stem and the thorns, and people give it away on Valentine's Day?" "Oh," says his buddy, "that's a rose." "Oh, that's it, Rose. Hey, Rose, what was the name of that restaurant that we went to?" "Oh, I told you it wasn't going to be any good." Oh, speaking of not any good, it was mentioned that Tammy's all excited about our new website. I am not, because these pictures, or this picture particularly of me, is going to be our new one, and the old one on the old website is 22 years old, and I'm really not happy about what the last 22 years have done to me. 5 kids can really do it to you. All right, we're going to talk about affirmative defenses and the burden of proof involving those. Whose burden of proof is it? Well, remember, the burden of proof always lies with whomever's trying to prove whatever. The applicant needs to prove AOE, COE. We, the defense, and it is that we are the defense, want to prove that we're not liable. So we're going to raise, among other things, affirmative defenses, such as the independent contractor, intoxication, willful misconduct, unreasonable conduct by the employee, prejudicial failure to give notice, not just the 1-year statute of limitations. We're actually going to talk about a much shorter one. Some of these defenses are codified, meaning if you go with your labor code section, you'll find them in there. Others are non-codified, meaning some judges decided to come up with something cockamamie but nevertheless, in this particular situation, gave us a good defense. Independent contractor, you've heard a lot about that lately with AB 5 and the Proposition 22, all that debate during the election back in November. The intoxication defense, 3600, my favorite. Prejudicial lack of notice, 5400. Statute of limitations, multiple. Felonious act, don't be a naughty boy or girl and get injured in the process. We'll talk more about that later. Non-salary partners, there's the old picture. I mean, it's still ugly, but you can see why I prefer it. Not nearly as much gray there. There are a number of employments that are specifically expressly excluded from workers' comp. You need to know when you're facing one of those. Subrogation, of course. Unreasonable failure to submit to treatment. Yeah, if they refuse to submit to treatment and it's unreasonable, it may be, well, it's not going to be a full defense, but it's going to be a partial defense, probably. All right. Continued non-codified, lack of jurisdiction. Injury caused by the applicant's S&W, serious and willful, of course. Now, remember, it's always the applicant's attorney that's claiming that our employer engaged in serious and willful misbehavior. But what's good is good for the goose is good for the gander. We can turn that around. And anytime I see that that applicant has done something, here's the technical term, really stupid to get injured, I always file an S&W against them. Willfully self-inflicted injuries, intentionally hurting oneself. Willful suicide, I guess if it's not willful, it's, well, it's murder. Initial aggressor, going and coming rule, oh boy, there's one. It's a great clear rule with enough holes in it to match Swiss cheese. Some more horseplay, love that's my favorite. Rashly undertaken activity, apportionment, coverage issues, general, special, and the claim is barred by a prior compromise and release. Finally, post-termination. All right, so there's a lot of defenses there, a lot. And we're going to go over them in a significantly greater detail. And by the way, I want to really thank you for signing up for an hour and a half. That's very brave of you. But, oh, a lot to wave goodbye to. Why would we wave goodbye to our defenses? Well, it's possible to waive, not W-A-V-E, but waive, W-I-V-E, that is failure to bring up and therefore lose all of these defenses, except for jurisdiction. Why would that be? Well, the WCAB can't do it to you if they don't have jurisdiction, regardless of how late it is. They can never gain something that they never had, and therefore you can't waive them into jurisdiction. So we need to file an answer. Who amongst you has filed an answer within the last week, the last month, the last year? Oftentimes I'll ask that in presentations and I'll get very few hands, and that's a problem. It's not just a shuffling of paper. The answer is really important that we waive or that we fill out. Why? Labor Code Section 5500.5. I promise I won't read too many statutes. I hate when they do that. Evidence upon matters not pleaded by the answer shall be only allowed by the terms and conditions imposed by the judge. Meaning, you have a going and coming defense, you have a post-termination defense, you have a this, that, or the other affirmative defense, and you don't raise it in a timely answer, the judge may say you've waived it goodbye. And you really want to rely on him. He's not on your side. So file that answer. Why else? Well, not only is it in the labor code that says it, the regulations say exactly the same thing. Affirmative defense is not pled. Now it's going to be up to the judge whether you wave goodbye to that defense or not. In short, failure to plead, and you're really taking a risk. And wouldn't your supervisor be pleased with you if they found out that you'd waived your defenses? Of course, the best defense ever, of course, is that the thing never happened. But let's talk about this. Here's an example of the waiver of the defense. So we've got a regulation that says you can waive it. We've got a labor code that says you can waive it. And we've got cases that say you can waive it. In this particular Ellis case, the defense screwed up, didn't raise an earnings issue in the answer. And it was held that they couldn't raise the overpayment at trial. In other words, once again, they waved goodbye to it. So when, where, how do we file the answer? Well, going way, way back, for those of you who remember back in '93, and sadly I do, as proven by the gray, we had to file and serve within 6 days of the filing of the application for adjudication. Prior to that time and post 1194, and meaning at the present time, we have to file that answer within 10 days after service of the DOR. Did you know that? I'll bet you at least 50% of us didn't realize that. If you don't catch anything else today, make a note of that. You could really save a lot of embarrassment. All right, so following the answer, the procedural requirements, use the board's form. You don't have to make up anything out of whole cloth. The form is there, use it. You can obtain it on the internet if you don't have it. General denials. I've often seen denials that say, we raise every defense within the labor code and case law. That's not going to do it. You need to specify you have to have specificity, easy for me to say. Specificity, and so you have to be mentioning these various affirmative defenses, whether they be in the labor code or in the case law or both. Advantages to an answer? Well, as we've just gone over thoroughly, it avoids waiver. 2, it assures timely notice of the defense issues. In short, you can imagine the situation where at the MSC you're ready to cut off discovery, and you're just raising a defense. Then the judge may say, "Well, okay, I'm going to give you a break. Well, I'll let you raise the defense, but we're going to continue discovery." And now applicants' counsel, if they've messed up on discovery, has a second bite of the apple. And of course, this focuses our discovery efforts. That's always a good idea. As it's stated right here, it's not like we're overworked with a bunch of pleadings. How many pleadings are there in workers' comp? I mean, formal, formatted pleadings. Well, the application for adjudication and the answer. That's it. Now, there are some we need to make up on our own, but in terms of formal, formulaic pleadings, that's it. So file that answer. What if you can't contain a mistake? I've had people say, well, I don't want to file it yet because I'm looking for this, that, or the other thing in terms of the facts, and I need to check that. Well, answer it anyway. Answer it anyway. Mistakes will be forgiven. Lateness, not necessarily, but mistakes will be. And we've got case law on that to that effect too. Going back to even 2010, there was a stipulation of an AWW of $750, and later we realized, no, just a minimum wager. At the pretrial conference, the defense tried to amend their admissions on the pretrial conference statement and said earnings are in dispute. And they were said and the judge said, no. You filed the answer. You said it, the AWW was $750. That's an admission, quote unquote. That in other words, that's going to be held against you. In short, rather than being a minimum wager, this person is suddenly a maximum wage earner for disability purposes. The WCAB said no. An answer is a mere pleading. It is not an admission. Admissions are a completely different animal. It is merely a pleading, which can be amended later before submission by the judge at trial. So what does that mean? It means file that sucker on time, put in as much information as you can. If you have to amend it, you can do it. We've got a long period of time before submission to determination by by the judge at trial. In other words, almost all the way to the end of the case. All right. Dynamics. You've heard of this case. I know you've had. In fact, I'm sure you've been hearing about it for the last 3 years. Any case that impacts workers' compensation that went up to the Supreme Court, we've probably run across it. Now, it didn't initially start out as a workers' compensation claim, but it did start as an independent contractor case. And we know independent contractor status is a defense in workers' compensation. Why is independent contractor status a complete defense in workers' compensation? Well, we only allow employees to be to receive workers' compensation benefits. Independent contractors are not employees. Well, in Dynamex, they were asking about independent contractor status. It wasn't a WCAB situation. It was the IWC and a wage order situation. But nevertheless, it was independent contractors. And it was held that there was a presumption that individuals are all employees. That's no big deal. That's been, that ruling is as old as dirt. However, here's the new stuff, and I hope you've heard about this. If you want Mr. Alleged Employer to prove that this person is not your employee, that this worker is actually an independent contractor and therefore not your problem, you have to pass the ABC test. And the ABC test is on the onus of the employer or alleged employer, the purported employer, the entity, the purporter of the independent contractor status must prove 3 things. Each of them, 2 out of 3 won't do the trick. That the worker is free of control and direction from the hiring entity. Free from control and direction by the hiring entity. And the employer may say, well, there's a contract here. We've got proof that they're free of us. We've got a contract that says I've hired them as an independent contractor and they can complete this task any old which way they want. For example, if I hired a pool service to build a pool in my backyard, and I would obviously have a contract to do so, it probably say that I don't have any control over what's going on. I would be able to prove that that one of these pool contractor folks, if they died or were injured, were not within my direction or control. That actually would be either via contract or fact. But think about this. What about Uber and Lyft? Is the driver free from the control and direction of the hiring entity, Uber or Lyft? That's debatable. That's why we had Proposition 22, because Uber and Lyft and their ilk wanted to make sure that they were not covered by this ABC test. Number 2, and the worker performs work that is outside the usual course of the hiring entity's business. This is interesting. I would have no problem with the pool contractor because, hey, I don't make pools. I barely do the law. I'm pretty much good for nothing, including bad jokes. But that being said, let's take a look at the Lyft and Uber. The driver performs work that is outside the usual course of the hiring entity, Uber and Lyft. Is that true? The driver drives, we know that. But is that outside the course of Uber, the course of the business of Uber? Most of us, I think, are going to say no. Uber says absolutely, positively yes. Uber says it's an application business. It provides connections between people who want to be independent contractor drivers and people who want a ride, but they're not a driving service. Well, we'll see. And the worker is customarily engaged in an independently established trade, occupation, or business of the same nature as the work performed. Well, would that be true of Uber and Lyft? In that one, that's going to be a debatable one. You probably need to have the worker also have a side job or another job as a limo driver or as a taxi driver, what have you. So remember, the employer, alleged purported employer, must prove all of these. In short, prove that the worker is in business for themselves. And without being able to prove all of these, they've got themselves an employee on their hands. Now, this case, the Supreme Court case, again, it was not dealing with the workers' compensation matter, but subsequent case law said, yes, this covers workers' compensation, and moreover, subsequent legislation said that this is going to cover all employees, or virtually all employees. As for our three-part test, probably, not in all cases, but probably be the performing the work that is outside the usual course of the hiring business entity's business. It's going to be the tough one. Now, let's give an example that really makes it a lot easier for Uber. Let's say Uber has utilizes a call center, or even better, their headquarters has a sanitation department, or not a sanitation department, but they have an outside service that cleans their floors every week, or a night service. Is the night cleaner service performing a business that's within Uber or Lyft's normal course of scope of business? Absolutely not. These are two totally different lines of business. So in this just particularly tough factor to prove, Uber or Lyft would probably get away with it. So anyway, we had this California Supreme Court, and then there was quite a bit of an uproar, and Assemblywoman Gonzalez came along and offered up AB 5 and said, I think this is a great idea, Supreme Court. I want it to apply to just about every employer out there. And it does, and it did, with rare exceptions. And those rare exceptions were usually made up of, in fact, almost exclusively made up of the kind of businesses that had very good folks fighting for them in the halls of Sacramento. So September 18, 2019, here's a gentleman who's fighting for his political life today. Odds are very good that he's going to win, but we shall see. He signed into law the ABC test for all employers not specifically excluded. And when so doing, he said that this test will, quote, help reduce workers' misclassification, easy for me to say again, which erodes basic worker protections like minimum wage, paid sick days, health insurance benefits, and of course, workers' compensation. And this went into effect January 1 of 2020, so we've been dealing with it for quite a while. Now, under the caption of when they say it's not about the money, and remember, he said it's about the worker safety, it's about the money. How do I know that? Prior to AB 5, the cost of the state of California was missing out on about $8 billion in payroll classes by what would be now considered misclassification of employees as independent contractors. All right, enough of that. We could actually talk about that for several hours. In fact, I have a presentation about that goes on several hours, and I'm already probably losing you to sleep. So let's go get drunk, shall we? That was either one of my worst days or one of my better days. By the way, I really wasn't drinking there. It was Christmas morning. At least I don't think it was we're drinking that morning. So if the applicant, the employee, now we're going to deal with employees, not independent contractors. If the employee is intoxicated, whether by alcohol or an unlawful substance, or strike that, unlawful use of a controlled substance, we've got ourselves a defense. Seems simple. They've been drinking a lot. They've been doing drugs. We've got a toxicity test. We got a police report. You would think we were all good. Not necessarily. Controlled substances, well, it's all the fun stuff. Yeah, it's all the fun stuff. Unlawful doesn't mean that I accidentally took a double dose. It means you broke the law, hence the word unlawful. It's a two-pronged test to determine whether it was obtained illegally. I used my wife's prescription, and or it was obtained legally. My wife obtained it legally, but I used it. Unlawful manner. All right, so let's go and continue with this. What do we have to prove? Well, we have to prove that we've got a covered intoxicant. And let's make it real simple. That's alcohol is the real easy and obvious one. So alcohol is definitely covered. But we also have to prove that they were intoxicated. Well, again, with a toxicity report or maybe even a police report, that's probably going to be, it's going to be more difficult than to prove that they've actually been drinking or taking in the intoxicant. Intoxication well, what does it represent? It represents the fact that they've somehow lost some control. Now, how much control has to have been lost? Well, enough control that we can blame the injuries or blame the alcohol or other intoxicant for the injuries. In other words, proximate causation. The intoxicant must have proximately caused the injuries. So let's say I'm incredibly drunk and I get injured in a hotel. You may say, okay, let's fill out the answer and intoxication defense, Barthel, go pound sand. And I might say, well, wait a second. I was drunk. I will stipulate. I was 3 sheets to the wind. I had 2 12-packs that night. And I was on the 12th floor. But then there was an earthquake and the hotel fell apart. Somehow I lived. Apparently I was very relaxed. And that's what caused my injuries. Well, I engaged in imbibing in the covered intoxicant alcohol. I was intoxicated, completely stipulate to that. But was the booze causing my injury? No, in fact, in this particular case, it actually salvaged me or saved me a little bit. I had less injuries because I was relaxed. But obviously, it was the earthquake's fault. A judicial lack of notice. What's the shortest statute of limitations? People generally say it's 1 year, but we're going to get to that. Well, strike that. I mean, I would give it some thought. What's the shortest statute of limitations? For those of you who didn't say, it's 30 days. They must file a claim within 30 days after the injury. Huh? How come we're not denying them successfully on the 31st day left and right? You've probably received within the last month a claim for an injury that occurred over 30 days ago. Well, the problem is it's not that clear. There's more to this statute. I read the statute as the dead witness statute. You have to prove that the employer, the defense, has suffered some prejudice as a result of the delay in the reporting of the claim. And of course, the employer has to also prove that the employee knew or should have known of the injury. So enough of that. Nice to have in our back pocket. If you're filling out the answer, hey, that's one more thing to consider. But we already have enough problems with the regular statute of limitations, which of course are 1 year. We'll say that in a second. Why do we have a statute of limitations in the first place? Well, it's kind of obvious. What if I filed a workers' compensation claim against my employer 20 years after the event? The witnesses may very well be dead. Evidence may have been destroyed, lost, or otherwise gotten rid of. May make it very advantageous to me, the employee, because I can make all sorts of allegations, come up with some evidence, a witness or what have you, and the employer, there may not be information available for the defense to just defend itself. So statute of limitations, what if there are no benefits provided? No benefits, no compensation, no treatment, no nothing. The application for adjudication must be filed when? Within 1 year of the date of injury that they knew or should have known about. What about if there were benefits provided? Well, then the application must be filed within, that's right, 1 year from the payment of the last benefit or from the last payment or benefit. What kind of benefits? What kind of compensation? What kind of treatment count? Well, sadly, anything. the employer provides anything and it relates to the injury or alleged injury, we've got a problem. All right, I'm going to skip right through this real quickly because what I really want to do is we've got 90 minutes and I'm going to really attempt to get you out closer to 60. I know you'll hate us if that happens, but if we do, I got one last joke to clean up with. I know you're excited about that. So the 90-day denial deadline. I know when does the 90-day deadline start counting? I know, by the way, we have new deadlines with COVID, but the traditional 90 days, and I think this is going to be applicable to the new deadlines as well. When does the 90-day clock start ticking? And oftentimes, folks will say, well, when I know about the injury, when I hear about the injury, when I hear something about an injury. Well, let's find out. There's actually a California Supreme Court case on it, and those are the bigwigs, so we can rely on them. Back in 2005, about a decade and a half ago, here's a situation. The employee complained about work stress, that four-letter word, work stress. A few months later, he was hospitalized, couldn't do any work in a psych hospital. So apparently there was some stress of some, or some psychiatric issues of some sort. The wife, while he was in the hospital, told the employer he was suffering from work. Once again, that four-letter word, stress, and said, I need a disability form. Well, what's a disability form? I don't know what a disability form is. It could be a whole lot of things. The employer said, okay, here's an unemployment form and fill it out. 6 months after the first complaints of work stress, applicant filed a TWC1 claim form. So it was denied 75 days later, filed or denied 75 days after the TWC1 claim form was received, but a long time after they first were told of quote unquote work stress. So it came down to this: is a denial that issues within the 90 days after the claim form was received, but 8 months after notice of work stress or injury, is that late? Well, you know what the WCJ said? It said, heck yeah. It said the employer was supposed to provide a claim form. If the claim form wasn't denied within 90 days, or rather, the claim wasn't denied within 90 days of that failure to provide the claim form, and therefore it is quote unquote presumed compensable. After all, that's what Labor Code Section 5402 says, right? If liability is not rejected within 90 days, the injury shall be presumed compensable. Let's find out what the WCAB said. The WCAB said, this is a very important issue, and we're going to make it an en banc decision. And they said, we agree with what the WCJ said. Aren't you shocked? The employee files a claim form, or the employer is quote unquote reasonably certain. Those are the magic words they use. Reasonably certain that the injury was suffered, or is being claimed, and they breached the duty to provide the claim form. Then that's when the 90 days start running. And of course, they sent it back to the judge and said, well, was the employer reasonably certain? And shockingly, the WCJ said, yeah, they were reasonably certain, and therefore it's presumed compensable, and therefore start the benefit train, defendant. By the way, just to make sure we're on the same page, what's an en banc decision? Real simple. First off, we normally just go to go to the WCAB or go online and do our trial. And either you win or you lose. And let's say you won. Well, because you were represented by the losses of Bradford and Barthel, that's not a shock. Let's say you lost. Maybe you chose to use another firm. I don't know. You lose. Well, normally what do? Well, we pay the benefits. But sometimes we say, no. This thing needs to be appealed. So what do? We file our petition for reconsideration. And we go up to the WCAB in San Francisco, the 7 commissioners, and the commissioners say, normally, we're very busy, go away, we have no time for you. That's the typical answer. They don't put it that way, that'd be kind of rude, but that's typically the answer. Sometimes they say, all right, we feel your pain. We're going to assign 3 commissioners, are we going to issue a panel decision. And that should answer the question as between you and the other side, the defense and the applicant or the allegedly injured worker. It's not going to decide it as between anybody else. By that I mean, if there's another case with that judge or any other judge in the state of California facing this particular issue, they don't have to follow the logic or ruling in this particular case. They can use it as guidance. It can be raised, and one or more of the parties can mention it and say, this is what the WCIB said in a panel decision, but they don't have to follow it. It's not the law. All right, so we have the options. First, the WCIB says, go away, we don't have time for you. Second, they say, we feel your pain. Come on, we'll give you a panel decision, and they'll decide it as between the parties here. And sometimes you file a petition for reconsideration, and the WCIB in San Francisco says, where have you been? We've been waiting for you. Now, they haven't literally been waiting for you, but they have been waiting for a fact pattern like yours, because apparently they're facing an issue or issues that can be found in your fact pattern that are being addressed by judges up and down the state of California, and the judges are going every which way but loose. That some are going this way, some are going that way. Nobody can decide exactly how that particular issue should be decided. In that case, they issue an en banc decision. Now, how many commissioners play? All the available commissioners. There are 7 commissioners sitting in San Francisco. That is the maximum we can have. We can have less when the governor has failed to appoint a replacement or 2, and we've been in that situation. In fact, at one point we're missing 3, I believe, within the last several years. But any and all commissioners who are available can play and should play, aren't involved in the decision. Does it have to be a 7-0 decision or 0-7 or 0-6? In other words, does it have to be a home run? No, it can still be an en banc decision and will still be an en banc decision, even if the vote is 3-4 or 4-3. So long way of saying, in Honeywell, the WCIB thought this was a very important case. And according to the WCIB, anytime we're reasonably certain on the defense side, the 90-day clock starts running. The California Supreme Court said, wait a minute, let's take a look at what the law actually says, commissioners, WCJ. Reasonably certain isn't in the statute. You're making up words that aren't really there. Let's take a look again at this. They held that the 90-day period begins from the date the employee files the claim form, not from the date, this is the court's words, not from the date the employer receives notice or knowledge of an injury or claimed injury. Think about this. What happens when the 90 days start? Your discovery requirements start. Let's say I've got an employee who I'm fully aware strike that. Let's say I'm deposing an applicant. And it's basic orthopedic, boring back injury with all the questions we've all listened to a million times. And about halfway through, the applicant starts breaking down, crying. We have to take a break. They get back on the transcript and they start breaking down again. And they say, I'm so sorry. This is actually on the transcript. I'm so sorry. The stress of this injury, the stress of the job, it's making me completely decompensate mentally. I've received medical attention from my psyche. I've been going to a therapist, a counselor, a psychiatrist. I'm on 1 million psychiatric and psychotropic drugs, all because of the stress of my job. And I say, hey, this deposition has suddenly gotten a lot more interesting. Now I get to take a psych depo. So instead of those boring orthopedic claim questions that we could all do in our sleep, now I can ask what? Anything that is reasonably calculated to uncover evidence that's of value, that is relevant to the claim. So I start asking juicy questions. And applicant's counsel says, objection. That's why okay, fine. I ask another juicy question. Objection. Well, why is applicant's counsel objecting? Real simple. He's actually right, and I never want to agree with that. No claim has been made. Applicant has not filed the claim form. Therefore, the 90 days of discovery has not started, meaning I have no right to start any discovery. I have no right to ask questions. I have no right to subpoena records or anything else for the psyche component. Why? Think about it. If you had a back injury, would you also file a psych component? I certainly wouldn't. I've got enough skeletons in my closet. I don't need somebody nosing around. So no matter how depressed I was, I wouldn't be filing. The employer may be knowledge that I'm receiving medical treatment or psychiatric treatment, but there's no way in the world I'm filing a psych claim. Just not a chance. By the way, I talked about juicy questions that you can ask in deposition. In 30 years of doing this, I've asked a few interesting, juicy questions, but this one tops the whole group of them. It takes the cake. I think that's what I was looking for. It takes the cake. All right, ma'am. Now remember, the objective is to find evidence that is relevant to his or her psyche. Ma'am, did you give your husband the STD, or did he give that to you? Objection. Now, there was no basis for objection on there, and we managed to get rid of the case fairly quickly. But it doesn't get much more interesting than that. Was it mean? Well, it was relevant, and that's my job. So it's the burden of the employee to notify the employer, notify the employer of the injury. The employer must provide notice to the employee of their rights and provide a claim form. And then it's up to the applicant or the employee, as I've just gone over through my example here, whether to file a claim form. Only when the claim form is filed does discovery begin. Or probably better stated, can discovery begin. Only once the claim form is filed or application for adjudication can the discovery begin. So 90 days runs from the date the employee files a claim form, not from, quote, the date the employer receives notice or knowledge of the injury or claimed injury. Now, the employer will be stopped, meaning you can't get away with this defense. You can't argue that you didn't run the 90-day statute. You will be stopped if, before the filing of the claim, you let the employer, or rather, knowing the employee has suffered an injury, refuse to provide them a claim form, or say in some way, shape, or form that none is available. Or you don't need to file that. Don't worry, we're buddies. And the employer has to prove, the employee has to prove that the employee was actually misled by the failure and suffered some sort of damage as a result. That is, their claim was was denied. So think about that. How is this going to happen? Well, for example, let's say, oh, Amir, he's going to be taking over in about 12 seconds. Lucky you. You finally survived me. Let's say he and I are walking along through the offices. He trips and stumbles and falls and breaks a leg. But who knows what else? He's claiming his back really hurt. You know how he is. And he says, "Oh, I better file a claim form." And I go, "No, come on. How long have we known each other?" "Well, a million years." "That's right. We've known each other a million years. I've got you covered. You don't need to fill a claim form. We will take care of it. I really don't want my comp rates to escalate, and you don't want that to happen either, do you?" "No," he says, "not a problem." Let's say, so if this issue comes up later on, is it possible that I'm going to be stopped from claiming that was the time when 90 days started ticking? Well, I knew that he'd suffered an injury. I refused to provide him a claim form. Was he actually misled and thus failed to file a claim form? He's an expert in workers' compensation who's been practicing for decades. I'm going to be arguing that he wasn't actually misled. So now you've been forewarned, don't file a claim form around me.
Not for purposes of this example. For the purposes of the presentation, I have half a clue. for purposes of this example, Amir needs benefits. He's got young kids, and that's all the audience needs to know.
The claim form is yours, my friend. The claim form is yours.
So I don't know what this says. I get the pleasure of starting with death cases and statute of limitations. Interesting little fun fact about me, I'm also the official, unofficial head of the large loss unit, which I like to call the Death and Dismemberment Department, or the Triple D. Tia does not like it when I refer to it as the Death and Dismemberment Department. She likes large loss or something boring and mundane like that. I think it makes for better marketing when you have a snazzy title like DDD, but she doesn't. So let's talk a little bit about death cases, shall we? Usually death cases and statute of limitations, the dependents have to file the application. And by the by, usually the applicant is dead, the injured worker is dead, so it's the dependents who file an application. Most ghosts do not. And they got 1 year from the date of death and within 240 weeks from the date of injury. No proceedings for benefits, for death benefits may be commenced more than 1 year after date of death, nor more than 240 weeks from the date of injury. If you get out a calendar and you try to multiply that by 7, or you get out the number of weeks and you try to divide that by 240, and you figure out where that 240 number comes from, please do privately message me back why the legislature picked 240 weeks. I haven't been able to figure it out. I don't know anyone who does comp that has been able to figure it out, so let us know why. Regardless, the rules of thumb there are statute of limitations. The dependents have 1 year from the date of death or 240 weeks from the date of injury. How about in asbestos cases? For death benefits in asbestos cases, proceedings must be commenced within 1 year from the date of death, regardless of the date of injury. And the reason there is kind of funky. If you can guess, please put that in the questions box or message us back. The short answer is because the date of injury is often in asbestos as a toxic tort injury way long ago. I'm talking about, forget 240 weeks, we're talking about 240 months ago. Sometimes it's decades ago. And after the injury, there's a latency period. That's the fruition period, for want of a better description, for how long it took for the injury to actually become harmful enough and result in death. So 1 year after the date of death in an asbestos case. Don talked earlier about the statute of limitations and how it's kind of a slippery slope, how the statute for filing the application gets pushed forward by providing benefits or by misleading an employee like me. If Don got out his Visa card when you guys did hear that, right? It's all well and documented that I did fall. I think I got both a knee injury and a back injury. It's forever on the internet. So my claim better be admitted to our comp carrier. But if Don gets out his Visa card and pays at the Dock in the Box down the street out of pocket, my statute just got pushed forward from him paying for benefits, right? Unlike that, the statute of limitations for us claiming, for the applicant claiming a serious and willful against the employer is not extended by payment of benefits, by an agreement to pay, by Don getting out his Visa card, or even by filing an application for normal benefits. In other words, it has to be filed within 12 months from the date of injury if the injured worker is alleging a serious and willful against the employer. Hard and fast statute there, pretty good for defense, or the employer's defense against an S&W. Similarly, 132A, proceedings are to be instituted by filing an appropriate petition, not more than 1 year from the alleged discriminatory act. That's another pretty hard and fast rule the injured worker has to meet, or the applicant has to meet if they're going to allege a 132A. Felonious Act. Is your criminal activity causing you heartburn? Call CAW. Operators are standing by. Now, I know this thing is being recorded and is going to be forever on the internet, so I hope I'm not offending too many of my brothers and sister members of CAW, but when it comes to felonious acts and felonies, and fraud, the central question is the injured worker in fact guilty of criminal activity? Then maybe the claim is barred, because sometimes instead of a pure bar, it's a possible reduction of the injured worker's benefits. Now, a lot of the stuff we're going to talk about, just like a lot of the stuff Don was talking about, we're looking at from like a 30,000 foot view, right? These are intros to affirmative defenses. For folks that have heard Don and I present before, either together or separately, you guys may have already noticed some of the changes we have in both the lineup for this presentation, as well as the issues and sub-issues, and that's because case law is constantly evolving. So we've updated a lot of this, we've reworked a lot of this, and we've added some things to the lineup. We've taken a few things out of the lineup. But my point is, like felonies, there are a lot of sub-issues on this. And one of the issues you're looking for felonies is, in order for it to be a purely non-compensable claim, the injury has to be during the commission of a felony for which the injured worker is convicted. Now, that conviction is not an opinion by your defense attorney, right? It's not an opinion by the employer. It's not an opinion by the combination of the employer and the defense attorney and the adjuster. There's an actual conviction here. That's done by a different court. In order for it to be non-compensable, think about how long we have to wait on the comp side for the conviction to come to fruition on a criminal law side. What happens in the meanwhile? Often you may find you had an admitted claim, or you had to pick up a claim because you went to an AME or some other twists and turns like that that resulted in us picking up a claim, and then later on, different court determines with a different standard of proof, beyond a reasonable doubt, that our injured worker was involved in the commission of a felony. So a lot of twists and turns here. Speaking of jurisdiction, some other types of defenses that are work-related but are outside of the WCAB. So these are claims that happen in the commission of employment, our employees at work, but they're just not subject to the WCAB's jurisdiction. These examples go on the next few slides, such as Federal Railroad employees and the Federal Employers Liability Act. If there's an injury on a federally recognized tribal land, sovereign immunity for that employer, Admiralty, and Jones Act. And let's see, I think we have a simple breakdown here. Yeah, at the bottom of 61 here, Longshore and Harbor Workers' Compensation Act. We look at local contacts. The more contacts there are on land, the increased chances that the WCAB will have jurisdiction. Because realistically, I mean, are you really involved in Longshore and Harbor's workers if you're on dry land? The more contacts that there are with water, then there's increased chances for Longshore Act. There are other examples. Death on the High Seas Act, that's a favorite of mine. Involved in piracy, yeah, you're probably not going to be at the WCAB. Maybe, I don't know, probably not though. Independent causes of action also are outside of the WCAB's jurisdiction. Examples there are, if there's a pregnant employee's fetus, that fetus has an independent cause of action. The fetus is not at work, was not an employee, was not injured in the course of employment or arising out of employment. Actually, on independent cause of action right now, in light of COVID-19 and the pandemic, we're seeing some cases meandering through the WCJs and the WCAB recon unit and into the Court of Appeal. Also separately through civil courts and courts of appeal by people claiming independent causes of action in situations where employees allegedly caught COVID-19 at work, brought it home, spouse, child, family member, household member is saying, I caught it from your employee. I don't work there. I'm not subject to WCAB. So we're seeing those independent or alleged independent causes of action meandering through the courts. It'll be interesting how that plays out in the next few weeks, months, years. Another independent cause of action is given to us by the Vehicle Code, 17150, negligent operation or loaning of a motor vehicle. means the owner of the car, often the loaner of the car to an employee, has independent cause of action. ADR, alternate dispute resolution, even if subject to the labor code, is a carve out, as we call it, from the WCAB. So those claims go into ADR processes or are carved out of the WCAB. The recons or the appeals, the primary appeals for the ADR cases do go to the WCAB's recon unit. Okay, let's talk a little bit about injury caused by the injured worker's S&W. This is where the employer is saying, you, my friend, you, my employee friend, got injured because of your own S&W misconduct. In that situation, 4551, Labor Code Section 4551 allows for a reduction of the compensation unless the injury results in death. So this is where the employee engaged in such conduct that is serious and willful and resulted in his own death. There's no reduction for death benefits. Similarly, if the employee engaged in such S&W behavior that they ended up with a life pension, no reduction. If there is also a violation of Cal OSHA, or if the employee engaged in S&W conduct under the age of 16. So let's start with D. I wholeheartedly agree with that, because I don't know about you guys, but I was engaged in all kinds of goofball, serious, and willful misconduct as a 16-year-old, as a 15-year-old, some would argue as a 36 and 46-year-old. Be that as it may, I agree with that. Recently, in light of COVID, I'm really grappling with A there. I have a case, I have a claim right now where arguably the employee, I think, engaged in S&W, but she died. And the dependents are filing a claim. Now, I don't want to memorialize on the internet what's going on there, but this is a real thing. It's a real thing here, and I'm not sure I'm going to get any reduction or even have a reason to file the S&W because of 4551A. All right. Now, here's funny little case law. By funny, I don't mean ha, ha, ha. I mean, like, wow, look at the poetic language. This is the type of behavior the WCAB did not think was serious and willful. They thought this was deliberate and okay and compensable. The injured worker here took a leap, took a jump off a roof. And the issue was jumping off a roof that resulted in your injury. Should that be subject to 4551 S&W reduction? Language from the case is, applicant did not leap with reckless abandon from the roof without considering the consequences. Applicant's hesitation, conversations with witnesses, and preparations show not wanton and reckless disregard of the consequences, but a process of deliberation and, unfortunately, miscalculation. Poor judgment, yes. Serious and willful misconduct, no. I think what happened there, I know you guys asked, so I'm going to answer. I think what happened there is the goofball employee was on the roof and said, hey, you think I'll be okay if I jump? Some simple goofy question like that, either out loud or in a bubble over the guy's head, is the hesitation and conversation and the preparation. So think about the standard. Think about the standard that's needed in order to establish an S&W against the injured worker. Another body of law or some other cases that have talked about an S&W really worry about the word rash and rash type of actions, activities that result in consequences and consequential injuries to the injured worker or other deviations from S&W. They're kind of interesting. I don't want to get too lost in the weed here, but they're interesting in the sense that they talk about the type of deliberations that the injured worker does, the type of activities the injured worker engages in, the standard of proof, very, very factually based behavior, very, very factually based defenses. Let's move on to willfully self-inflicted injuries. This is straight out of the statute. This is not really case law driven. This is statute driven. In order to win against a willfully self-inflicted injuries, the employer must show that the employee's actions were intentional and the employee's behavior was not merely negligent, and the injury was caused by the intentional act, and the injury was either the intentional result or reasonably foreseeable. So let's talk about a little quick example. I get frustrated. I'm giving you guys all of this information. I'm making all of these witty jokes. None of you guys are laughing at my humor, and I punch the wall in anger, in frustration. I break a finger. You know, that happens. Are you guys going to be able to defense and deny me successfully my broken injury, compensable injury? And I think the answer there is no. You can't deny me benefits there. Did I intend to hit the wall? Yeah, I kind of did. Is my behavior negligent? Probably not. I think I intended to do it. Was the injury caused by an intentional act? Did I mean? Was it my intentional result to break my finger? I was just venting frustration, if anything, right? I didn't mean to break the finger. Now, if you say, hey, Don, I'm going to break my finger at work, that ain't arising out of employment. That's willfully self-inflicted injury. Okay, willful suicide only covers where employee willfully and deliberately meant to cause own death. If you don't mean to cause your own death, what is that? That's murder. That's homicide. That's a whole different lecture we'll put together. Or it's just natural causes. That happens too. At any rate, in order to win against in order to prove a willful suicide claim against the dependents, what we have to show is that the death was self-inflicted, that the injured worker wanted to die and took specific steps, and that there's no connection between the industrial injury and the latter, suicide. Because what the injured worker's dependents will argue is that it was an irresistible impulse. I've actually, unfortunately, had to defend one or two of these in my death and dismemberment department. So what we had was a situation where the employee was capable of taking his own life and took a deliberate action. I believe he swallowed a bullet at full speed. He did so, and the reasons I had to show were personal and were independent of prior industrial injury. What you want to look for is a suicide note. If the suicide note says, I'm tired of my husband, I'm tired of my wife cheating on me, that's enough. That's probably not work-related. It was probably a willful, non-industrial suicide. If the suicide note says, I'm tired of you are denying me my 17th MRI this month, my chiropractor is convinced that the 17th one would help her figure out how to treat my headaches, we got a problem, because MRIs, chiropractors, headaches, all of that are work-related allegations or type of stuff we see. So that the dependents may be able to successfully, probably are going to be able to successfully argue was work-related. Okay, anyway, initial aggressor. How am I doing on time? I'm okay. Initial aggressor. I got 20 minutes to get through half of the affirmative defenses. I think I can do it. Wish me luck. Here we got to show that there's an altercation in which the injured employee is the initial aggressor. What happens is Rocky picks a fight and Rocky gets hurt, and then Rocky wants comp benefits. So there we got two big old questions at the 30,000 foot mark. And there what we're asking is, who initiated the altercation, or was the initial physical aggressor? Not physical contact. Who was the initial physical aggressor? Does not mean who actually caused the initial physical contact. And what's the subject matter of the dispute? To be compensable, the injuries must be work-related. If they're fighting about who gets to go out with John on Friday, if they're fighting about who gets to go out with Jane on Friday night, those employees are not probably talking about work-related stuff. Sounds personal. That's not going to be compensable. So number one, subject matter. Number two, we got to figure out, when you talk about who initiated the physical aggressor, There we got sub-issues. There we have to look at the victim, the intended victim. The victim who ended up being the stronger person, perhaps. Anyway, was that intended victim suffering from real subjective belief that she or he was in danger of being attacked by the coworker, number one. Number two, was that objectively reasonable? Does not mean that the intended victim had to be hit. They could have popped the other person first. So in these situations, you get a lot of he said, she said. You get, now he started it, now she started it. Finger pointing. Sometimes you have two claims represented by two different applicant attorneys. What you want to do there is join those claims, join those cases at the WCAB so you get one judge, so you have one compensable applicant, because the victim, the real victim, should probably get comp benefits. The aggressor, not so much, shouldn't get benefits. Speaking of not get benefits, another exception is the going and coming rule. Generally speaking, injuries that occur during commute ain't compensable. Why? Because if you're commuting to work, you ain't at work. If you ain't at work, you ain't working. If you ain't working, not compensable, right? That's a theory anyway. There's so many exceptions to this. It's got more holes than Swiss cheese. There's a Swiss cheese Don was talking about earlier. So generally speaking, going to work, coming home from work, barred. However, lots of exceptions. We could spend another 90 minutes talking about those. You know the rule. You know there are a lot of exceptions. Let's talk about a different type of injury during travel. These are med-legal injuries or otherwise to treatment appointments. I tried to break this down simply in one slide. Again, this is 30,000 foot level here. Lots of sub-issues, but at the 30,000 foot level, if the employee is injured while traveling for treatment, compensable, there's a citation. If the employee is injured while going to a med-legal, well, then we got some sub-issues, okay? And let's take motor vehicle accidents as an example. If the industrial claim is admitted and going to an AME, admitted injury, going to an AME, there's a pretty recent case that said, yeah, it's industrial. I don't necessarily agree with it. I think med-legals should be barred because there's nothing that forces you into litigation. But the logic there is you agreed to the eval because you agreed to the claim in order to figure out how much you owe and something you admit. So there you are. What if you don't admit the claim and you send the employee to a med-legal? Then arguably, if the AME comes back and says it's not industrial, and how many times do you see that, folks? When was the last time any of y'all saw an AME come back and said it's not industrial? So in that very exceptional situation, the MVA may arguably not be work-related either. So Don, you guys all heard this on the internet, right? Forever memorialized on the internet. Don deny me, mislead me into getting benefits. Well, this is where revenge comes to get you, Don. If you're a non-salaried partner, Don don't get benefits. Why does Don not get benefits? Don doesn't get benefits because this is called workers' compensation. If he's non-salaried, if he's an owner, Don's an owner, his name's on all of our paychecks, Don's not a worker. DRB don't get bennies. Not employers' compensation. It's not partners' compensation. Now, there's a lot of exceptions here, too, so I can already tell the crowd grumbling, and you're rightly grumbling, but in general, owner-operators may be exempted from WCAB. Also, you guys know that I can't count. We went from 79 being the 12th defense to 80 being the 14th defense. Who knew? You guys came for law, not for math. Okay, credit for comp paid from third-party recovery. Another 30,000 foot level intro to an affirmative defense. If the employee recovers from a third party, then we get credit for that. We file for WCAB petition for credit. We may also want direct recovery from that third party in the third party action or in the third party claim. Lots of issues, lots of sub-issues, sometimes multiple jurisdictions. Please contact us if you have any questions or concerns there. We have a subrogation department headed by the bottom left of your screen, Peter Fitzpatrick. Great guy, very knowledgeable. Also reach out to Tia. She's got a wonderful story about walking into civil court, and I'll save that for her. Got 15 minutes. I think I can do it. Number 15 and 16. 15 is unreasonable refusal to submit to treatment. 15 again is unreasonable refusal to submit to treatment. 16 is unreasonable refusal to submit to examination. What's 15? 15 is if you're at your claims desk and you have ongoing TD, you're on day 46, your diary comes up that says continue TD, yes or no, and you don't have a current medical. The injured worker blew off her medical appointment yesterday with the PTP. Number 16 is you thought you were going to have a med legal in order to figure out if it's finally time to stop TD for this ankle sprain that's had 18 MRIs, and the injured worker blows off the QME, blows off the med legal. What do? Well, you can't control them missing an appointment, but you can control what happens afterwards. What happens afterwards is you notice the next appointment. So that's like step 2, right? Missing appointment number 1 was not you. Step 2 is you set the next appointment and you notice it, right? So set next appointment, next PTP or next QME, next med legal, and you notice it. Then you get a petition to compel together, or you tell your attorney, hey, quickly put this petition to compel together. She files the petition to compel. You get an order to compel the next treatment appointment, the next med legal appointment, and after that, your denial of TD or your DOR to an expedited or something like that has a little bit more bite. Another affirmative defense is horseplay, also known as skylarking, also known as goofing around. And these are basically another set of affirmative defenses or an affirmative defense that has lots of factual information and discovery that has to be done. Generally, we're looking for an employee's activities that are personal in nature, that are for convenience, that had an inherent potential for injury, and then an injury happens, even though that was not the intent. We've all been at work with this guy, right? He wants to shoot rubber bands at you. He wants to spit with straw wads at you. He wants to fling paper clips at you. He wants to dare you to do handstands on ladders. He wants to encourage you to sniff glue. Yes, these are all real examples that Don found from cases. These are not work-related. Your coworker telling you, hey, let's make paper airplanes, and then one of you guys puts an eye out, that ain't arising out of employment. That's arising out of boredom. Shooting rubber bands at each other, goofball stuff, not work-related, I submit to you, even if it's done on a double dare. So these are very factually intense inquiries and defenses. You can also see how these might have overlap with S&W. So if it's an S&W, you can have both. You should assert both if the right facts and circumstances arise. But if you are able to successfully demonstrate horseplay, that should be a full bar. If you're only able to show S&W type of activity, then you get a 50% reduction potentially. So good stuff. Apportionment. Let's try to keep this one simple. Simply speaking, PD is applicant's burden and apportionment is defense's burden. And let me tell you, apportionment is defense's burden. So in the final analysis, the same type of stuff that the injured worker uses to establish PD, the AMA guides, a rateable report, is what we should use in order to establish apportionment, right? You look for an earlier MRI, pre-injury, that shows radiculopathy. Bango, I'm feeling good. If it's a back, I got a lower back prior DRE3, I would argue. Somehow it just doesn't work out that way. When the MRI happens after the injury, all judges get it. Amir, you need to tell your client to pay more. I show up with an MRI that has positive findings the day before the injury at work. What does the same judge, the same aggravating judge tell me? Well, I said a finding of PD. You can't prove it. Just want to reach through the court call and, talk to them. Okay, another few defenses. These are usually asserted by a carrier, and they are lack of insurance coverage of the employer. It may be work-related, but we don't insure this employer. Another affirmative defense is we don't insure your employer because there's a general special rule, or we do insure your employer We just did not insure you while you were working at this job site because there's an exclusionary endorsement or policy restriction because it's a construction case and that construction is subject to a different carrier's coverage. If you do have coverage, in issue, it is subject to mandatory arbitration. Coverage denials do not go to the WCAB. You have to start simultaneous mandatory arbitration under 5275A. Often, when I'm denying coverage, I'm also denying employment because I'm saying not only are you not working for an insured entity, this employee may not have worked for that employer. You work for a different employer on that job site. So we're running two different defenses at two different jurisdictions, meaning mandatory arbitration and WCAB for employment. So there you want to ask the applicant attorney. Even if they don't agree right away, often they will after a while of agreeing to move the employment issue to voluntary arbitration in ADR so we get consistent results. General and special employer, this is where we are basically arguing you may have gotten hurt at work, but you are not an employee of our insured. Lots of sub-issues here. Site-specific is another one of them. This is where the carrier is saying you worked at a job site, injured worker, that is not insured. It is subject to a different carrier's coverage, and you want to look at the actual coverage policy to make sure you have a good affirmative exclusion, number one. Then you got to look for the correct carrier's information. Sometimes you're pulling local permits in order to figure out who they said was going to be in charge of this construction policy. You have to reach out to the broker. You have to get declarations. Lots of factual and lots of discovery intake there. Let's see here. Oh yeah, war story on coverage. I've even used the broker's email back to me saying, yes, we specifically excluded this job site in order to get a petition for dismissal filed, and much to my pleasant surprise, the judge there granted it, got us out. Woo! All right. Also, it does help if you're going to use something like that to have the correct carrier join. So you want to do a petition for dismissal and for joinder. I use my broker's email in order to say my client, let's say carrier A, was not the carrier. Broker said we gave coverage for this job site to carrier B. Winner, winner, chicken dinner. Prior CNR. Prior CNR is another affirmative defense. This is the coveted claim defense that we all look for, that the WCAB fights us hard for. I'm going to try to keep this one simple for time purposes. It's basically where we are saying that the claim has already been settled by a prior CNR. You want to make sure that you try to settle all claims of injured workers and dependents in the CNR. Everyone listening, I'm sure, has run into situations where the WCAB says, no, you can't settle all claims, whether known or unknown, filed or unfiled. So we try our best, and the WCAB fights us their best as well. Let's talk about a few psych affirmative defenses in the minutes we have left. One of them is good faith personnel action. 3208.3H says no compensation under this division shall be paid for a psych injury if the injury occurs or was substantially caused by lawful, non-discriminatory, good faith personnel action. The burden of proof is on who? The burden of proof in order to establish a good faith personnel action is on me, your attorney, you, the claims examiner, is on defense, because we have the affirmative on the issue here by statute as well, aside from 5705, as Don went over earlier. So we got to establish that we had a lawful, non-discriminatory, and good faith personnel action. This is going to need lots of factual inquiry, lots of discovery. We're going to need witnesses. We're going to need people in our human resource department at our insured helping us out, giving us coworker names, giving us supervisor manager names, helping us identify performance issues, helping us with the actual write-ups, their personnel file in order to show why the person was fired or why the person was involved in a good faith personnel issue. It doesn't have to be necessarily termination from employment, although that's often the situation. If you do have a termination from employment, applicant may claim that that termination was in retaliation for claiming an injury. Then you also have to get the cadence of events in order to figure out what came first. Did the claim come out before the termination? Did the termination happen? And then you have a post-termination claim, because post-termination claims, as you know, are another affirmative defense. Okay, other psych exceptions that may mean a claim is compensable is if you have a victim of a violent act. Let's say the injured worker on day one of employment suffers from a stick-up as a cashier at a liquor store. Day one, stick-up, cashier, liquor store. You're going to want to deny it, saying you're not really worried, you're not really stressed out, you're not really nervous because it was your day one. We got an exception. Woohoo! They're going to allege, and I think successfully allege, victim of a violent crime. They don't necessarily have to be shot. Having a gun stuck in your face seems pretty violent enough. I hope that doesn't let you guys think or lead you guys to think that I wouldn't defend it for you. Number two, catastrophic physical injury. If they suffer from a, quote, catastrophic physical injury within 6 months of start of employment, then claim they have a compensable psych injury, they're stressed, they're nervous, they have PTSD, whatever the psych claim may be, it may be compensable if it is deemed, quote, catastrophic. Again, that's a 30,000 foot level introduction, lots of issues and sub-issues there. Let's see here. 6-month rule, I already went over that. Gosh, that 100 probably should be moved earlier. At any rate, other exceptions to the 6-month rule are if the injured worker has, cumulatively speaking, more than 6 months of work. Does not have to be consecutive. So in that kind of situation, think of a nurse, for example, for a hospital or a medical facility, injured after 5 months on the job, but worked earlier in time while in nursing school for 2 months at that same hospital, at that same employer, at that same insured during nursing school. So wasn't a nurse back then, but cumulatively, even that volunteer work, because it became a part of her work, her lead up to work, is going to be tacked on. Similarly, work after the injury can get tacked on if someone claims compensable psych injuries after the physical injury. We talked about unpaid work, like being an intern. Being a victim of violent act is also an exception. Let's see here. Sudden and extraordinary events are another exception to the scope, to a psych claim. And I try to break these down in my mind of thinking of them like occupational hazards. So a tree trimmer falling out of a tree, what would be the main occupational hazard or a pretty big occupational hazard of a tree trimmer falling, Well, it's got to be falling out of a tree, right? If they claim, hey, I fell out of a claim, I got a psych injury, I think you may have a straight face defense and say, no, that was within the foreseeable occupational hazard. That's not sudden and extraordinary. That is not a sudden and extraordinary event for a tree trimmer. But if your work comp defense attorney falls out of a tree, I think I'm going to have a compensable psych claim, because what's the occupational hazard for a work comp defense attorney? Falling out of a tree ain't one of them. So hopefully that kind of oriented you folks, or reoriented you folks to a lot of our defenses, our affirmative defenses. And I want to thank you guys for allowing us into your lunch hour. Hopefully you learned a lot, and we look forward to the opportunity to meeting you again, hopefully real soon. Thank you.